Good day, Crime Talk aficionados. It's Saturday, August 6th. What does that mean? That's right. It's a recap of all of the top stories that we brought you throughout the week, all located in one convenient location here on the Best of Crime Talk. Have a wonderful day. We'll see you next time. Enjoy the video. All right, Dylan Rounds. Remember him? He's the 19-year-old farmer who left his Idaho home to work a plot of land in Utah. He's been missing for 2 months. Well, it's Rounds' 20th birthday today, August 1st. Mr. Rounds' mother says, "I'm hanging in there the best I can, but not knowing is pure torture," according to his mother, Candace Cooley. Now, James Adrian Brenner, a 58-year-old man who was squatting on a neighbor's land, is being held on federal charges and has been named a suspect in Rounds' disappearance. No charges have been filed in direct connection to the missing persons case of Mr. Rounds. Now, Brenner was convicted of shooting and seriously wounding another man at a campsite in Maryland in 1986 in a work-related dispute. He has numerous other convictions over the years, and he served federal time as well. Now, when Dylan Rounds was not located early on in the search effort, the investigation focused on the possibility of Dylan being the victim of a crime. This is according to the Chief Deputy Cade Palmer of the Box Elder County Sheriff's Office. Now, according to a neighbor identified in court documents as DH at some point after Rounds' disappearance, Brenner asked him to conceal 3 black powder guns and a .22 caliber rifle without a serial number. After being contacted by the FBI, DH gave the weapons to authorities. Citing past felony convictions, they charged Mr. Brenner with being a felon in possession with a firearm. Another local man, Chase Venstra, is also facing federal firearms charges in connection with the case. Authorities served a search warrant at his home prior to Rounds' disappearance, and they found 2 guns. After listening to jail phone calls after the team went missing, police said they learned he had more weapons hidden with an associate. Nearly 2 months after the Johnny Depp trial has been over regarding defamation, well, guess what? The actress has quietly sold off her California desert oasis. The 3-bedroom, 3-bathroom Yucca Valley estate, which sits on 6 acres of land in California, was sold off the market. Now, the property records show that on July 18th, the home traded hands for $1.05 million. The home goes to a New Jersey couple, Richard and Carol Jeanette Jorgensen, who also own property in Nevada and are founders of Jorgensen and Company. It's unclear how the Jorgensens discovered the off-the-market home or if there's a direct connection to Miss Heard. Now, Miss Heard purchased the home for $570,000 back in 2019, walking away with a hefty profit. But considering the $8.3 million that she was ordered to pay Depp after being found liable for the defamation by a jury, every penny is going to help. Now, as you may recall, Amber Heard was ordered to pay $10 million in compensatory damages plus the $350,000 in punitive damages. And what normally happens after judgment is awarded, when the judgment is final, liens are basically filed. The transcript of judgment is filed in every jurisdiction where somebody can find that there is a debt that is owed. Apparently, this was sold before that was taking place, but now everybody needs to make sure that it was a fair market value transaction. There wasn't a preferential treatment, or the judgment creditor could try and claw back any sale if they think that it was worth more. It's interesting, though, how it just happened to sell right before all this went down. I'm sure somebody will make an issue of it in court, but maybe Johnny Depp won't because, well, remember he said it's not about the money. All right. Now, there's been some newly unsealed documents that show that Ms. Heard walked away from a divorce payout that could have run into the tens of millions of dollars. Now, these unsealed documents show that Heard had her request denied from lawyers to seek half of Depp's $33 million he made filming the 4th installment of Pirates of the Caribbean since it was made while they were married. Now, thousands of pages in these documents filed in the Johnny Depp Amber Heard defamation case were unsealed over the weekend, including text messages between the actor and Marilyn Manson and his team's apparent attempt to bring up his ex-wife's brief stint as an exotic dancer at trial. The records show a series of behind-the-scenes moves by attorneys from both sides to get certain claims presented to the jury in the Fairfax, Virginia trial. One 965-page document filed March 25th detailed Heard's opposition to a series of motions made by Depp's lawyers, including one to exclude his medical history from the trial and others that asked to present potentially damaging information about the actress. Lawyers for Heard said Depp sought to inappropriately bring up Amber Heard's sister Whitney's reality show video and Whitney and Amber's past romantic relationship, the court files state. Depp also wanted to tell the jury about Amber's brief stint as an exotic dancer years before she met Mr. Depp, her lawyers wrote, as they also opposed Mr. Depp attempting to frivolously and maliciously suggest or imply that Miss Heard was at one time an escort. The documents also showed new text messages between Depp and rocker Manson, whose real name is Brian Warner, who had been accused of sexual abuse and grooming, including by his former fiancée, Evan Rachel Wood, whom he sued for defamation in March. Now, in a 2016 text, Manson allegedly wrote, "I got an Amber 2.0, and also Lindsay just pulled an Amber on me. Please delete." Depp responds, "I've been reading a lot of material on that, and sociopathic behavior is an effing real, my brother. My ex, the C word, rhymes with punt, is goddamn textbook," he said. I did the rhymes with punt because you don't say that word. Then Manson, in an apparent reference to an incident where the police were called to Depp and Heard's shared Los Angeles apartment back in 2016, wrote, "I got a serious police Amber type scenarios with L's family. I'm effing stressing. I don't know if you're back, but I need asylum somewhere because I think the cops might be headed my way." Now, Heard's lawyers allege that Depp and Manson went on a drug binge together, including days before the actress arrived in Australia, and the two got into a now infamous fight that ended with the actor losing the tip of his right middle finger. The filing also includes a lengthy passage of allegations that Heard's attorney, Elaine Brendenhoff, claims she was unable to ask Depp's former agent, Tracy Jacobs, about, including that the actor lied to the LAPD, included in the list of relevant and damaging information excluded at trial. Well, that Mr. Depp was appearing on TV drunk and stoned to the point that Disney executives called Miss Jacobs asking what the hell was going on with their client. It's not clear what alleged appearance the attorney was referencing in the court filings. Ms. Heard's team also claimed that these same issues appeared during the filming of the Pirates 5, and Disney told Ms. Jacobs that the conduct was not going to be tolerated. Disney was not going to put up with this, and that there was no love between Johnny and Disney given the Pirate 5 situation. Now, remember, Depp's relationship with Disney played a major role in the trial, and his lawyers argued that Heard's defamatory allegations cost him tens of millions of dollars in future Pirates revenue, while Heard's team argued Disney dropped the actor due to his own behavior. It is always interesting what comes into the jury, what was really the actual relevant information, or the court determined to be irrelevant. Well, needless to say, lawyers for the actor said Heard's team was offering misleading evidence, stating that Brendenhoff could have kept questioning Miss Jacobs for further 3 hours, but chose not to do so. Documents also show how Depp's attorneys excluded testimony regarding the actor's arrest record and ongoing litigation for other cases, including a lawsuit accusing him of assault that was settled last month. It will go on forever, ladies and gentlemen. And in another court document that was released, Amber Heard's sister apparently admitted the actress had cut off Johnny Depp's finger during an incident back in Australia. A newly released transcript of Jennifer Howell said during a deposition that witnessed Heard's sister, Whitney Henriquez, received texts from the actress in which she admits to her role in the violent incident. She, the sister, just screamed, "She's done it now." She cut off his finger and made this huge proclamation. Hal, an art curator, recalled, Hal also testified, and she goes, she cut off his finger, and then she bolted out of the door and was like, I gotta call somebody. And she went out the door and she called someone. She doesn't know who she called, but that's what she said. As I've stated from the beginning, the Amber Heard Johnny Depp saga will continue for years. It will provide great information and great content for the news and YouTube creators, but it just proves my point that the whole world is dysfunctional regardless of how much money you have. Frankly, it may make you sometimes a little more dysfunctional. The first story we have today is a hero that is developing, okay? And how did we find out about this hero? Well, we monitor what takes place in the Lori-Vallow Chad Daybell matters. Well, interestingly enough, there was an order that came out and said that there's going to be a hearing on August 16th at 9 a.m. before Judge Boyce in the Chad Daybell matter. So the question then becomes, is this a hearing regarding the motion for consumptive testing that had been filed previously by the prosecution? Or could it be a motion filed by an attorney who is now a writer and a member of the media? That's right. So let's take a look at these motions, okay? There's a motion to intervene by a woman by the name of Lori A.G. Hellis. And she basically says she wants to intervene in the case, basically says, I have reason to be involved in these court proceedings. And she is basically challenging the court's decision to close hearings and seal documents and in general, limit media access to court records and proceedings in this matter. This is great. And this is her motion to intervene. And she cites Idaho Rules of Criminal Procedure 24 and Idaho Court of Appellate Rules 32. She's also filed a declaration of intervener and intervener memorandum of facts and applicable law. This is great. I just wish, I guess I was considered a true member of the media. I don't know. Do I get like media credentials somewhere? You know, we should, maybe we could intervene with her. The other motion that was filed by Miss Lori A.G. Hellis in both the Lori-Vallow and Chad Daybell matters is a motion to unseal all documents and transcripts or recordings of past hearings. Hear. This is good. And she wants the court to review all of the sealed records and recordings of hearings and properly redact all statutorily protected information before unsealing those documents and recording into the court records. That's fair. There are certain things that are private, and we'll get to that. And then here's her declaration. I love this. Declaration in support of motion to intervene and the motion to unseal and a motion for injunctive relief. Ms. Hellis states that she is a retired attorney licensed in both Oregon and Arizona. She is inactive in both jurisdictions, but in good standing because basically she's retired. She's a published author and holds valid press credentials with International Federation of Journalists. In addition, she is presently under contract with Pegasus Books to write a book about the Daybell case, and therefore she's a member of the media. And in this consolidated matter, the court frequently has and consistently limited the public and the media's right to access hearings and documents without a prior hearing or sufficient justification. She cites Idaho Appellate Rule 31 and the Idaho Constitution, a United States Constitution that requires that the public and the media be permitted access to court records and proceedings subject to certain limitations. The rules further require that the court hold a hearing after notifying all interested parties before sealing documents or closed proceedings, and Idaho law recognizes the legal standard of members of the media to intervene in court matters for the limited purpose of challenging the media's right to access court documents. Good for her. This is getting good. And then her memorandum in support of the motion to intervene. And it basically starts off that she has standing as a member of the press and that she is petitioning to do this. And like good legal writing, she starts out with facts, okay? Facts. This matter came before the court when defendants Chad and Lori Daybell were charged, and they list all the case numbers. The sealing of court documents began almost immediately. The following entries in the court record indicate sealed documents are closed proceedings, and she lists them all. She goes on for several pages, 2 pages actually, of citing all the hearings and all the orders that have been sealed. And then, like good legal writing, after outlining the facts, she states the law. She cites the United States Supreme Court, which has consistently recognized that the Constitution conveys a presumptive First Amendment right to access to judicial proceedings to the public and press, finding that a presumption of openness inheres in the very nature of the criminal trial under our system, citing the case of Richmond Newspapers versus Virginia, which is a 1980 decision. She also states that the United States Court of Appeals for the Ninth Circuit, which includes Idaho, also recognizes a constitutional right of access to court records, noting that the public and press have a First Amendment right to access to pretrial documents in general. And when considering whether a constitutional presumption of access applies to a particular proceeding or record, courts apply the logic and experience test, also called the press enterprise test. The test considers whether the place and process have historically been open to the press and general public, and whether public access plays a significant positive role in the functioning of the particular process in question. Ladies and gentlemen, I noticed this early on. I've been troubled by it. I've called out Idaho for this. I've called out Judge Boyce on this. I cannot think of a situation where you cannot go into just about any courthouse and sit down and plop yourself down. I don't care what the nature of the case is, whether it's a homicide case or an SAOC case, anything along those lines. You can sit in there and watch as a member of the public. And there's no way in hell that the court can kick anybody out. That is a violation of the defendant's right to an public trial, a public hearing. You can't kick people out. And when the courts start doing that, and if the defendant's objecting to this, the problem in this particular case for the defense is they've been going along with it. They're not objecting to it. They should be saying, I want all this information out there. I don't know why they're not saying, no, Judge, this is, my client has a right to a public trial. Let's put the information out there. Maybe something will change. Maybe something will change by this argument to basically say, Judge, you're violating the law. I continue. Ms. Hellis cites that in Idaho, access to civil and criminal court proceedings are broadly provided for in the state constitution. Courts of justice shall be open to every person, and a speedy remedy afforded for every injury of person, property, or character, and the rights of justice shall be administered without sale, denial, delay, or prejudice. Specifically cites the Idaho Constitution, Article 1, Section 18. In addition, Article 1, Section 13 of the Idaho Constitution specifically ensures that criminal trials are to remain open. Specifically, and I quote, in all criminal prosecutions, the party accused shall have the right to a speedy and public trial. Sounds just like, constitutional right, United States Constitution, right? Sixth Amendment, right? Exactly. To have the process of the court to compel the attendance of witnesses in his behalf and to appear and defend in person and with counsel. There are no Idaho cases interpreting the open court provision of Article 1, Section 18 of the Idaho Constitution, other than to say the Idaho State Code, Section 19-811, which allows a criminal defendant to request that his preliminary hearing be closed, is not unconstitutional under Article 1, Section 18, so long as the magistrate court issuing such closure order complies with the requirements of press enterprise, which we talked about a moment ago. Instead, the few cases that address access to court proceedings rely on the rights of a criminal defendant to a public trial under the Sixth Amendment to the United States Constitution, or to the qualified right of the media and public to access to court proceedings under the First Amendment. Although Idaho courts have not explicitly recognized a constitutional right of access to court records, the Idaho Court Administrative Rules 32, promulgated by the Idaho Supreme Court and grounded in First Amendment principles, provides broad access rights and procedural protections for the public. The public has a right to examine and copy the Judicial Department's declaration of law and public policy, and to examine and copy the records of all proceedings open to the public. And then there's an Idaho Code, Section 74-101, which memorializes Idaho's Public Records Act, and nothing in the act or its exemptions entitles the court to seal and thereby deny the public access to the court records. And under Rule 32, it specifically states that physical and electronic records may be disclosed or temporarily or permanently sealed or redacted by order of the court on a case-by-case basis. And it says that any person or the court on its own motion may move to disclose, redact, seal, or unseal part of the record in any judicial proceedings. The court shall, which is mandatory, hold a hearing on the motion after the moving party gives notice of all the hearing to all parties to the judicial proceedings and any other interested party designated by the court. The court may order that the record immediately be redacted or sealed pending the hearing if the court finds that doing so may be necessary to prevent harm to any persons or persons. In ruling on whether specific records should be disclosed, redacted, or sealed by the court shall determine and make a finding of fact as to whether the interested privacy or public disclosure predominates. If the court redacts or seals records to protected predominating privacy interests, it must fashion the least restrictive exception from disclosure consistent with the privacy interest. And what are those privacy interests, you may ask, Scott? Well, let me tell you, because Ms. Hellis has gone to the trouble to do it for us. 1, that the documents or materials contain highly intimate facts or statements, the publication of which would be highly objectionable to a reasonable person. It's a homicide case. I think everything is pretty much open to the public. That the documents or materials contain facts or statements that the court finds might be libelous. It's a criminal case. The parties pretty much have immunity from anything they say. Okay. C, the documents or material contain facts or statements, the dissemination or publication of which may compromise the financial security of or could be reasonably result in economic or financial loss or harm to a person having an interest in the documents or materials or compromise security of personnel, records, or public property for property of or used by the Judicial Department. I don't think we have that in this case. Or the documents or materials contain facts or statements that might threaten or endanger the life or safety of an individual. I can't think about that. I mean, the people are in custody, for goodness sakes, right? That is necessary to temporarily seal or redact the documents or materials to prevent the right to a fair trial. The court can impose a gag order so the attorneys don't do it, but the public should have a right to know what is being filed, what are in these statements. If the government screwed up, as is alleged in various motions filed on behalf of Miss Lori Vallow, then the public should know. It goes directly to whether the prosecutors are competent or not. Are they following the law or not? And there's been nothing to say that just because there's public information about a trial that people can't receive a fair trial. Think about of all the cases where there's news and information out there about a case. But you know what? Only thing that matters is what is the legal and competent evidence that is presented at trial. That's the only thing that matters. Is it admissible in court? That's what the jury is going to make their decision upon, not what's in the news, not what's being talked about by anybody else. I think the jury can make that determination, and the court can do that as well. And then finally, the document contains personal data identifiers that should have been redacted pursuant to the Idaho Rules of Electronic Filing and the Rules of Civil Procedure. Okay, we don't need people's social security numbers. I get it. Private information, medical records. I get that. That's fair game. But everything else should be open to the public. I've been saying this from the beginning. I don't like the way they do this in Idaho. And frankly, I'm a little surprised that the Idaho press hasn't filed any of these motions, that a book author has to be the one to move this issue to the forefront for the court. Everyone else just kind of went along with it. I guess I complained about it, but it just kind of went along with it, I guess. But at least This hero did something. Now, the argument that Ms. Hellis makes is that the drafters of the rules intended the process to be onerous, and the purpose or the specific procedure outlined in the statute encourages the process to be used sparingly and with due consideration. So just because it's a high-profile case doesn't mean that it gets, the rules don't apply. Remember, these are the rules that everyone has to follow. And the argument continues, there is no indication that the court even considered the factors in the Rule 32 because the court did not conduct a hearing as required by statute. Neither did the court document his findings on the record and in writing as the rule requires. There is no proof that the court considered whether any exception to Rule 32 applied. In fact, there is no indication that the documents or materials contain highly intimate facts or statements, the publication of which would be highly objectionable to a reasonable person. The documents may likely contain a fact or statement the defendant and or the lawyers for the state and defense may find embarrassing. No provision in this rule permits the court to consider that when deciding which records to seal. There is no indication the document or materials contain facts or statements that the court might find libelous. Likewise, there's no suggestion that the document or materials contain facts or statements, the dissemination of public which may compromise the financial security or could reasonably result in economic or financial loss or harm to a person having an interest in the documents and materials. And there's been no suggestion that the documents and materials contain facts or statements that might threaten or endanger life. This court has made a single finding that it is necessary to seal or redact documents or materials to prevent the right to a fair trial. The court has never expressly indicated how the defendant's right may be at risk and has never said in his decision to seal that the record is temporary. I love this argument. The public's First Amendment right to access public records regarding this case has clearly been violated. The court decided to seal documents without a hearing, without notifying interested parties, and without making written findings necessary to seal. Further, the court made no effort to avoid sealing by using a less restrictive method, such as redaction. This rule is clear, and even when documents contain personal data identifiers, the remedy is redaction pursuant to the Idaho Rules of Electronic Filing and Service, Rule 15, Idaho Rules of Civil Procedure 2.6, the Idaho Rules of Family Law Procedure 218, not wholesale sealing. The court's decision violates Idaho statutes and rules, including Title 74, Chapter 1 of the Public Records Act, as codified in the Idaho Statute 74-102, and the Court Administrative Rule 32. To date, the court has not published any public findings indicating whether privacy interest is being protected, how the privacy right predominates the public's right to disclosure, or what alternatives to wholesale sealings were considered. The court has not considered the free enterprise test, considered whether the place and process have historically been open to the press and general public. Public access always plays a significant role in ensuring that the defendants receive fair trials and competent representation. In fact, public access is at the very heart of the rule. The argument continues. Neither the court nor the litigants have provided evidence that actual damage or prejudice will occur if the sealed documents and proceedings are unsealed. This is a death penalty case. The court has previously pointed out that such cases are different and require higher care and scrutiny. Nowhere is that true in a case of sealed documents and proceedings. How can the public or the victims be assured that such a sensitive matter is being prosecuted appropriately and fairly without access to the proceedings and documents? Moreover, the higher the level of care requires that the court take the time to fashion a less restrictive way to balance the rights of the defendant and the rights of the public. And in summary, the legal presumption in both Idaho law and the United States Constitution is for the release of court records, with the court sparingly applying the exception to the rule. The court to date has been doing the reverse, sealing court records and waiting for someone to object. The court's actions to date violate the victims and the public's First Amendment's right. The wholesale sealing of court records does not comport with the law in Idaho, the court rules, or the Constitution of the United States of America. Lori A.G. Hellis, thank you. You should get a Hero of the Day award. I've complained about it, but I haven't done anything about it. I guess I'm not really sure if I qualify as press, but I guess we're going to have to get that sorted out so that if something like this happens again, or maybe we file a very similar motion so that we can do that as well. Because I've never seen a case that I can think of where there's been such restrictive access to documents in a case. And I've said it many, many times that I'm offended by it. And I don't like the way Idaho's been conducting the rules. But Miss Hellis, she went the extra mile and filed it. And, maybe that issue will be addressed at the hearing that the court set on August 16th. Or somehow maybe we'll be dealing with something else. But at least somebody is objecting now. I'm a little surprised the prosecution isn't doing it. I don't understand why they have a problem with the public record being disclosed out there. Usually you don't want something out there because it's going to be embarrassing to you. Frankly, there's, the victims in the case, obviously, unfortunately, have passed away. What is it to them? Basically, the prosecution doesn't want their law enforcement techniques shown to the public. Maybe explains why it took so long to charge this case. I don't know. Was there incompetence? Was it great police work? We don't know because we haven't had access to any of the documents that would normally be turned over. So, Ms. Hellis, if there's any assistance that I can give to you, please do not hesitate to contact me. Ms. Hellis should get the Hero of the Day award if we had one here at Crime Talk. Maybe we should. Good on her. I complained about it and I did nothing. I apologize. Like many Americans, we got a dog during the pandemic. My quarantine dog, Miss Winnie the Bulldog. Now, Miss Winnie has grown accustomed to being around us all the time. When we were leaving the house, Winnie would have extreme anxiety, so we decided to look for natural products to help with her anxiety. We looked for the highest quality CBD treats, and we were not satisfied, and neither was Winnie. So we created a high-quality CBD product that absorbs faster and provides the required results faster. Baked in Colorado, CBD treats and beverage enhancers are made with nanotechnology. The nanotechnology makes the CBD extraction more pure, also allows for Baked in Colorado products to work faster. Baked in Colorado products can help reduce your pet's anxiety, ease joint pain, and help with your dog's skin problems. Go to our online store and see what Baked in Colorado product is best for your dog. When you order at bakedincolorado.com, enter code WINNIE and receive 15% off your first order. We have a 30-day money-back guarantee. If your dog does not experience the desired results in 30 days, return the product and we will refund your money. No questions asked. All right, next on the docket. Remember the guy we talked about yesterday who, Monday was defending his mother's honor, I guess, or her opinion that the fries were cold, and then got into a fight with the employee at McDonald's? Well, guess what? The Brooklyn McDonald's worker who was shot in the neck over the cold fries incident has passed away, according to the police. Now, Matthew Webb, he was 23, and he succumbed to his injuries after he was shot Monday outside the Bedford fast food restaurant where he works, according to the New York Police Department. The attack has been deemed a homicide, and the investigation remains ongoing, according to the police department. Now, Michael Morgan, who's 20, has already been charged with attempted murder and criminal possession of a loaded firearm for, shooting Mr. Webb in anger at his mom getting served cold fries. Now, he's expected to face upgraded homicide charges. Prosecutors told a court hearing late afternoon, even before Webb's death was confirmed. Now, when the workers began apparently laughing at Miss Fulmer, she was FaceTiming with Mr. Morgan. That's the mom to her son, who came to the restaurant and got into a fight with Mr. Webb that spilled out onto the sidewalk. Morgan allegedly punched Webb in the face, and when he got back up, he pulled out a gun and blasted him in the neck, according to the prosecutor's theory. His mother later told police that her son told her he gotta do what he gotta do. Now, the suspect's girlfriend, Camille Dunlap, has also been charged with weapons possession for allegedly handing Morgan the gun. She was arraigned later Wednesday afternoon and held on a $50,000 cash bail after prosecutors said that she admitted to possessing the gun. Now, Morgan was already charged with an earlier homicide after allegedly confessing during questioning about the McDonald's shooting. That's right, which brings us to our quote today. If there were no bad people, there would be no good lawyers. Just remember that, ladies and gentlemen, because lawyers, the good ones, get a lot of practice.